cases that shape the way we understand freedom of expression, patriotism, and even cinema in India. Today we are breaking down to K.A. Abbas versus Union of India, Naveen Jindal versus Union of India, and Bijoy Emunal versus State of Kerala. Let's dive in. Hello and welcome back to At Ease No Media, where we discuss media related topics at ease. So let's begin. First thing first, K.A. Abbas versus Union of India. It took place in the year 1970. Censorship and cinema. It talks about nothing but the censorship and cinema. Now, to put it straight, our story begins in 1970 with K.A. Abbas, a journalist and filmmaker. He made a movie called A Tale of Four Cities, which showed the reality of life in Bombay, including censors from the red light area. You know what? Here's a twist. The censorship board said that this needs an adults only certificate. Abbas wasn't happy. He argued, why should the government censor films? Isn't that a violation of freedom of speech and expression under Article 19(1)(a? Obviously, but the issue then government censored film before they are released. This particular issue states that before the release, before this 1970, government didn't censor films. And the judgment by the Supreme Court says, yes, censorship of film is valid. Why? Why it is valid? Because movies have a stronger impact on people than newspaper or books. But, and this is important, we must filter, we must censor. Not every content is meant for everyone, right? So they tend to mislead, they tend to misbehave, they tend to take that thing seriously and which affects the society. So, the power of censorship must be exercised reasonably and within the framework of Article 19(2). That means reasonable restrictions. So the Supreme Court says yes, the censorship for film is valid, and the question begins why? Because movies have a stronger impact, as we all know, on people than newspapers or books. But it is important, the power of censorship must be exercised reasonably, right? And within the framework of Article 19(2) with the reasonable restrictions. Now, what is the significance of this case? This case laid the foundation for films and film certification in India, the balance between creative freedom and social responsibility. Isn't it? So this was the first case what we are talking about, K.A. Abbas versus Union of India. It was back in 1970. So the key things which we must understand, which we must remember, is the Tale of Four Cities. It got A certification instead of U. It is the Cinematography Act of 1952. The K.A. Abbas was a journalist and filmmaker, and you know what, they made a short documentary. The name of the documentary, as you can see, is the A Tale of Four Cities. The film showed the contrasting life of the rich and the poor. It shows the contrasting life between the rich and the poor of which section of Bombay, including some shots from the city of red light district. The censorship board refused to give it. They refused. They urged to refuse. What? The censorship board refused to give it a U. That means unrestricted certificate. And instead gave a A, that means adult only certificate. So Abbas challenged this, arguing that pre-censorship of film violates his right to freedom of speech and expression under Article 19(1)(a) of the Constitution. So if we talk about the issue, it was nothing but the pre-censorship of films is constitutionally valid, or whether it violates the fundamental rights of freedom of speech and expression. The judgment states that the Supreme Court upheld the validity of film censorship It reasons that films are powerful medium that can be deeply influenced emotions and public orders more strongly than books or newspaper. Therefore, censorship is a reasonable restriction under Article 19(2) of the Constitution. However, the court also directed that censorship must be exercised carefully. The court had ordered that they are giving censorship, but it must be directed responsibly and carefully, right? With clearer guidelines. This case, now what is the significance of this 1970 K. Abbas versus Union of India case? This case established the constitutional bias for film certification in India. It took a new turn in the film industry. It gave the birth of the from the particular Cinematography Act, it came the abbreviated part. Now it balanced freedom of expression with public morality and order. You know, Center Board of Film Certification, the CBFC, it led the evolution of Indian film certification. Prior to this case, there were no CBFC. That means this case led to the evolution of India's first film certification framework through the Central Board of Film Certification. See how much influential this K.A. Abbas was. He took this case because in this particular slide, in this particular note, what we can see that we will be just discussing about the most landmark cases that became act. Now in short, K.A. Abbas versus Union of India is a case that made film censorship legal in India. Prior to this, it was not legal. Constitutional limits. Now, if we talk about 1901 and 1902, then what it is? 1901 means we are having the particular freedom, we are having the particular rights. Now 1901 is stating us that yes, we have the particular rights, but 1902 is stating that we must use it responsibility. Article 19(1) as it guarantees 6 fundamental rights, if you can remember, of freedom to the Indian citizen. These are parts of our fundamental rights. The main freedom under Article 19(1) is that we have the Article 19(1)(a), that is the freedom of speech and expression. We have Article 19(1)(b), that is freedom of responsible and peaceful assemble peacefully and without arms. In Article 19(1)(c), we have what? We have freedom from association or unions. In Article 19(1)(d), we have freedom to move freely through the territories. We can move anywhere. So it is Article 19(1)(d). In Article 19(1)(e), we have freedom to reside and settle in any part of India. In Article 19, that states that freedom to practice any profession, trade or business. Now Article 19, as Article 19(1) is giving us this freedom, Article 19(2) states the reasonable restrictions. However, these freedoms are not absolute. They are giving the freedom in Article 19(1), but that is not absolute. They are giving reasonable restrictions. The state can impose reasonable restriction on freedom of speech and expression. Article 19(1)(a), in the interest of sovereignty and integrity of India, we must not infringe the sovereignty and integrity of India. We must not infringe the security of the state. The friendly relation with foreign states must be maintained. Public order must be there. Decency or morality must be there. Contempt of court. We must not contempt the court. We must not defame others. The incitement to an offences. So, just Article 19(1) guarantees freedom. Article 19(2) puts boundaries, restricts to the protect society, law and order. Now, K.A. Abbas versus Union of India, Abbas argued the censorship violates right under Article 19(1)(a), that is freedom of expression. And the Supreme Court held the censorship is allowed and reasonable restriction under Article 19(2). That means K.A. Abbas is stating that they are infringing Article 19(1)(a), that is freedom of expression. The court said yes. And the court also ordered that in Article 19(2), it states that the censorship must be allowed as reasonable restriction under Article 19(2), which is public order, morality and etc. So this was it with the K.A. Abbas versus Union of India in 1970. So see you in the next lecture where we will be discussing about Navin Jindal versus Union of India 2004. Thank you for connecting at Ease No Media, where we discuss media related topics at ease.